I have a lot of associations that want to solve this problem of a unit owner has an HVAC unit. This is the biggest issue usually, and it hasn't been repaired, hasn't been maintained. Now there's a negligence clause in there that a lot of associations can use, but they kind of need to do some work possibly before it gets damaged. And I know Roger, president of SCCA, has something that he does. A roof inspection before hurricane season is a great way to deal with this. Go up on the roof, make sure everything's good, take some photos, see if there's work that needs to be done, get it done. While you're up there, depending on who the contractor is, do the same thing with the roof ACs. Take pictures, see that the strapping is strong, see that the unit is in good, see that all the units are in good repair, and if not, possibly notify the unit owners and say, hey, this unit is in disrepair. If it falls off due to a gentle breeze, that's not going to be on us. That's going to be, per the negligence clause, it's going to be on you, even though HVACs are covered property under 718.
There's an assumption made sometimes that the owner automatically maintains the HVAC system, those portions outside the boundaries of the unit. That's not an assumption to be made. That's now you go to your documents. Mm-hmm. Who maintains the different HVAC components? Some documents put that on the association. So then there's no owner negligence if it's not the owner who has the obligation. So you have to first look into the documents, and there's a trap based on a couple of cases out of the state that if the HVAC system is outside the unit boundaries, and that would be the case for the compressor, and it says in the declaration the owner maintains, the only way that's legitimate is if those HVAC components are a limited common element. There's a case, one declaratory statement and one arbitration case where a drafter, a lawyer, recommended amending the documents to shift the responsibility for a component, I can't remember which one it was, from the association to the owner. It wasn't that way before. But it was never defined to be a limited common element. The drafter neglected to go to the limited common element section and say those are. And the reason is, if it's a common element alone, only the association can have that obligation. If it's a limited common element, then the DEC may then put that responsibility on the owner. So I've seen some declarations where it's on the roof, outside the boundaries of the unit, not a limited common element, owner maintain, not enforceable. So I look at that. Now that could be an area to have to amend, is just to call it a limited common element. It legitimizes the responsibility put onto the owner.